Well, hello there. And in this episode, I'm going to talk about the whole think of the children phenomenon. Unless you know, they're like think of the children unless they're LGBTQ or have LGBTQ parents when it comes to conservatives. So that's what we're talking about in this episode of the quadruple D. So, the Supreme Court's conservative majority appears ready to back a group of religious parents challenging a Maryland public school district's refusal to let students opt out of classes or lessons featuring LGBTQ characters. The case, brought by a coalition of Muslim, Christian, and Jewish parents in Montgomery County, centers on the school system's decision to integrate inclusive storybooks into its elementary curriculum, books that the plaintiffs argue violate their religious beliefs. Hmm. So, at the heart of the case is whether public education should be subject to individual religious vetoes. The parents argue that requiring their children to read books that depict LGBTQ families and gender diverse characters infringes on their First Amendment rights. They point to opt out allowances in sex education and ask why similar exemptions can't be made here. So, really, they're admitting that the opt out of sex education is sort of like a gateway drug, I suppose. That's sort of a silly way to look at it, but it's actually like almost accurate. They're sort of admitting that here. It's the slippery slope. Of course, critics of the lawsuit note a deeper issue. The parents aren't just objecting to sex education, they're seeking to suppress representation of LGBTQ existence altogether, even when it's not sexual in nature. The stories might not be outright pornography or whatever, but they will claim they are just because they acknowledge that different types of people exist. So the contested books include Prince and Knight, a fairy tale romance between two men. There's also Uncle Bobby's Wedding, a simple story about a girl concerned her uncle won't spend as much time with her after marrying his male partner. And Love Violet. It's about a girl working up the courage to give a Valentine to another girl. Other books like Born Ready feature transgender children expressing their identity. These narratives mirror the themes of countless classic children's stories. In other ways, they might have love, bravery, and self acceptance, yet they are rejected by the plaintiffs simply because the characters are different. And you can't have that, which is a little bit strange because the Christian Bible is supposed to be about accepting people who are different from yourself. Not only does it say to welcome, a stranger, but it even says that you're supposed to love your enemy. So what's going on? We've got the Republican Jesus in operation yet again, in effect, and the case isn't about protecting children. It's about religious groups trying to police what stories are allowed in the public sphere. This is just one of the ways they're trying to do it. Justice Brett Kavanaugh, siding with the parents in question, he questioned why the district wouldn't accommodate their beliefs, invoking Maryland's colonial era status as a refuge for Catholics. But historical tolerance for religious minorities doesn't justify modern demands to erase marginalized voices under the banner of liberty. Because, I mean, what is even being infringed on here? The right to not read a certain book. That's, I mean, okay, all right. But I can guarantee you that these same religious families, in a lot of cases, they would be fine with state sanctioned religious beliefs. They just don't want to have, the themes in question being addressed in the classroom. Well, I'm sure some of them would be fine with books that were against those groups, but you can't have anything that acknowledges that different types of people exist, and that, hey, that might be all right. That might be okay. Not everybody who is different from you is a villain. And I'm not saying that all of the parents in this case would consider themselves bigots or anything like that. I'm sure some of them would see themselves as just wanting liberty or whatever. But at the end of the day, liberty in cases like this is ultimately a sort of disguise for bigotry. So, allowing religious objectors to dictate public school content, it would open the door to widespread educational censorship. It really would, and that is one of the real intentions here. I guarantee it. If LGBT families can be erased today from books, what stops similar objections to lessons about racial justice, interracial marriage, climate change, or evolution? I just did an episode of my podcast where I looked at, the segregation era. And back then they were saying that race mixing is communism. That was what they were saying with their signs, their protest signs. And they were trying to say we have to keep the races separate. And really, what exactly is the difference here? Is that really so different from what these concerned parents are doing here? Not really. Those same segregationists, they were not in favor of the freedom for LGBT people either. That's guaranteed that that they were bigoted in that way as well, because that's what right wing ideology quite often is. You have these people who are just afraid of change, and oh no, it's so spooky to have these different groups. We gotta separate from them. And religious conservatives often frame these debates around parental rights and moral autonomy, but what they seek is not freedom from state overreach, it's the power to control the state's message when it conflicts with their ideology. They want to, get rid of any sort of conflict with their own, I guess, worldview. Public schools exist to serve everyone, though, not just their opinion, not just their worldview. And if representation of diverse people is grounds for an opt out, then so too is any content that challenges any group's worldview. You could say, I want to opt out of any acknowledgement of the existence of Christians, for example, in a public school. There's really no fundamental difference there. In fact, an argument could be made that objecting to, the acknowledgement of different religions is actually more of a thing that people could do, because religion is more of a choice. The sexuality that a person is born with is actually not a choice. At least, not at the core. I know people can experiment or whatever, but I'm talking about, like the unchangeable nature of attraction, the basic core of it. Not just like, oh, I had I'd experimented in college or something like that. No, I'm talking about the core elements of somebody's identity, what they're mostly geared toward biologically, their attraction. And the Montgomery County School District initially permitted parents to remove children from the lessons, but they later reversed that decision, saying the opt outs became disruptive and stigmatizing for LGBT families. The lower courts sided with the schools, noting the importance of inclusion and the impracticality of granting individualized curriculum carve outs. But the religious plaintiffs found a sympathetic ear in a Supreme Court that's repeatedly elevated claims of religious discrimination in recent years. Their argument hinges not just on disagreement with the material, but on a belief that exposing children to LGBTQ people is inherently inappropriate. That's really the premise here, that their existence is fundamentally corrupting, and it mirrors long-standing homophobic tropes, not evidence-based reasoning. And like I suggested, it also mirrors racist tropes. You know, the idea that race mixing is inappropriate, as you saw during that segregation era that I was talking about. And there really is no huge difference between the two. You know, there there is a similar premise in both types of concerned parents. And look, I can actually sort of meet the argument halfway. I get some of the basic critique of the sort of liberal school here, but from kind of an anarchist lens, you know, I can see that the question becomes, why should any state institution have the final say in what children must be taught, especially when those institutions can be co opted by religious or political agendas? But the answer isn't to grant opt outs that reinforce bigotry, it's to challenge the coercive systems, be they religious or governmental, that seek to dominate public education in the first place. The reality is, I mean, even though public education is considered to be tied in with government, the basic premise of education, of learning something, doesn't require the state at all. I mean, let's be plain about that. I'm not even saying, let's do away with public education or let's do away with government, but at the core here is, what are people being taught? How are they being taught it? And is there just an attempt to impose a bigoted point of view here, or is there actually more of a discussion that's being really obscured? I think in a lot of these cases, because it becomes, you know, oh, the poor kids, they're being led astray, they're being confused by these lessons or whatever, and that's not really the core issue. The core issue is what is factual, what actually has educational value, and so on. So the fear mongering from these parents, it's a lot of BS. I don't think it has more legitimacy than the segregationist views that that really were dragging this country down. But at the same time, there can be a healthy debate about what public education means, what it should look like, who can, you know, have their material in the classroom, etc. That there will always be some legitimacy to that debate and discussion. But, that's really not the entirety of what is happening here. So the court's decision, which is expected this summer, will likely set a national precedent on whether personal faith, or whatever they want to call it, can be used to block exposure to social realities. At stake is not just LGBTQ inclusion, but whether education is a pluralistic thing, reflecting a pluralistic society, or if it must be narrowed to suit the most restrictive beliefs in the room. So, that's really at the core of the specific topic here, not just any old critiques we could make of public education and the nature of, government or whatever. It really is a choice between, do we want our children to be intelligent and understand that different types of people exist, or do we want them to be stupid and ignorant? That kind of is what it comes down to. All right, so I have another segment of this show that I call the peripheral poop head of the week. And this time, we're looking back at a dead guy, actually. But he's still in the periphery because he's had a lasting influence. And I'm talking about Ken Starr. And he's relevant today because Brett Kavanaugh, who of course is on the Supreme Court, began his career as a law clerk working under Judge Ken Starr. So, Kenneth Starr was a U.S. lawyer and judge best known for his role as independent counsel in the 1990s, during which he investigated President Bill Clinton and produced the Starr Report. The very title of which makes it sound like he's a star. You know, the I think I think that's kind of funny how that works out because he did that to become a bit of a right wing superstar, and as a fun little aspect of that, and was called the Star Report. So it's like, I'm a bright shining star who released this report, and it led to Bill Clinton's impeachment. It's a funny little coincidence. Anyway, Starr's career also included significant controversy, notably his tenure as president and chancellor of Baylor University, where he faced criticism for mishandling sexual assault allegations. Well, wait a second, wasn't Bill Clinton impeached over, some improper sexual behavior? Isn't it a little bit odd to have, Ken Starr's career uh, ending because of, the mishandling of these allegations? Well, yeah, it's a little curious how that turned up happening. So Starr's role in Clinton's impeachment was pretty well known. He initially was appointed to investigate the 1991 suicide of Deputy White House counsel Vince Foster, but Starr's mandate expanded to include the Whitewater real estate investments involving the Clintons. And despite extensive investigations, the Whitewater probe did not yield conclusive evidence against the Clintons. And Starr's inquiry later encompassed President Clinton's affair with White House intern Monica Lewinsky. So, man, it's almost like they were weaponizing the government against Bill Clinton. I thought they only did that against Donald Trump. What the hell? You know, is that what we're told all the time, that this is a unique thing that was started by the Democrat Party, as they always like to call it? Well, wait a second. If you look back, during the Clinton administration, they were really going hog wild trying to find stuff to pin on the the president of the time. The investigation concluded that Clinton had lied under oath about the affair, leading to his impeachment by the House of Representatives on charges of perjury and obstruction of justice. But that really didn't pan out exactly. So fast forward to his tenure at Baylor University. In 2010, Starr became president of Baylor University, a private Baptist institution in Texas. His administration came under scrutiny following revelations of widespread sexual assault allegations, particularly involving the university's football team. So it sounds like they weren't just playing with, one type of ball, they were handling other balls over there. And, they were involved in some sexual improprieties. And investigations revealed that university officials, including Starr, failed to adequately address the allegations. So, as a result, Starr was removed as president in May 2016 and resigned as chancellor shortly thereafter. By August 2016, he had severed all ties with Baylor, almost as if he was disgraced or something. Hmm. How about that? It's fun to follow politics sometimes because so many of these people end up being disgraced in some way, almost as if they are a disgrace somehow. Anyway, in 2020, Starr joined President Donald Trump's legal defense team during his first impeachment trial, drawing criticism due to his previous role in Clinton's impeachment. You know, and yeah, that was quaint. Anyway, we don't have to worry that much about Starr anymore because he passed away in 2022 at the age of 76. So, for my third segment, I do the fetid fever dream flashback of the week. And this week it's George H.W. Bush. And it's because he's linked to Starr as well. Starr served as the U.S. Solicitor General from 1989 to 1993 during the presidency of George H.W. Bush. So I'm going to look at one of the biggest scandals from the George H.W. Bush era. And for some people, the biggest scandal involving George H.W. Bush is the Iran-Contra affair, even though it primarily unfolded during Ronald Reagan's presidency. Bush was still vice president at the time, but his proximity and involvement made it a lasting stain on his own political legacy. So I'm just going to do a quick overview here. What was the Iran-Contra affair? Well, correct me if I'm wrong. I'm just, trying to get the basic facts scraped together. But in the mid-1980s, the Reagan administration secretly sold weapons to Iran, which was under an arms embargo, and used the proceeds to fund the Contras, a right-wing rebel group in Nicaragua fighting the socialist Sandinista government. This was actually illegal on two fronts. And hey, that's kind of quaint, aren't they the party of law and order? But they were, barred from selling arms to Iran. It violated a U.S. embargo. And funding the Contras violated the Boland Amendment, a law passed by Congress specifically prohibiting such funding. So isn't that cute? Like, they violated an amendment that was specifically created to address this very crime. Bush publicly claimed he was out of the loop, but declassified documents and testimony suggest he attended meetings where the arms sales were discussed and supported aid to the Contras. So, again, one of the ironies here is that, this is supposed to be the party of law and order, and they're really just breaking the law at their convenience. And it really actually kind of feeds that anarchist perspective, an anarchist would see this and they would say the Iran-Contra scandal isn't just a political mistake, it's a textbook case of state criminality. Officials knowingly broke laws passed by their own democratic institutions. And of course, there's an imperialism angle. It involved violent interference in another country's self-determination, prioritizing U.S. geopolitical power over the will of Nicaraguans. Aren't they supposed to be small government? Why are they caring about what happens in Nicaragua? That seems like big government to me. And there was secrecy and unaccountability, of course. The scandal shows how little control citizens have over what their government does in their name, especially in foreign policy, which is, a bit of a scandal unto itself. But Bush's role fits into a broader pattern where elites can break the law with few or no consequences. Several officials were convicted, but later pardoned by Bush himself in 1992 just before leaving office. So, isn't that quaint? Why does that sound so familiar? Oh, it's part of a long standing pattern of just pardoning our criminal pals, when we're leaving office. Ugh, what justice? That move was widely seen as a cover up to protect himself and others, and from the aforementioned anarchist lens, it demonstrates how the legal system exists primarily to shield power, not to uphold justice. That might be a cynical view, but what do you know? These politicians so often will feed into that cynical view. So the bottom line here is that when it comes to the Iran Contra scandal and Bush's involvement, it's a clear example of how even the supposed moderates in government are deeply tied to illegal war making and power games. So it's not a bug in the system, it's the system working exactly as intended, power protecting itself. And yeah, there's really a lot to be learned from looking back at these past examples too. And I guess if nothing else, we can learn that the more things change, the more they stay the same.